Well, and I guess that's my whole point is it's a balancing.
Right.
I mean, on the other hand, are you going to say that the employer has to expose himself and his company to liability if that employee is left in that position and later contracts, lung disease or something that is a workplace hazardous condition?
Well, I think that's a very slippery slope. An employer does and I think that's exactly why we're here. Their employers sometimes get overly energetic in how they are viewing those situations for their protection, and they end up crossing the line and harming an employee. It would be hard for me. I mean, you'd either the employee is qualified for the position and has to be able to do the position. If the employee is, I guess I'm trying to think of what specific situation would occur where employee A would be impacted differently than employees B, C, and D by the same work environment. Employee A would have to have some genetic proclivity, I guess, to have that disease or that manifestation. As an employer, boy, I sure wouldn't want to be making those distinctions with that employee. I think you need to be able to protect yourself, but not to the point, as an employer, I would never want to get into that level of information, medical information or decision making with the employee's health issues. I think they're either qualified for the position or they're not qualified, and I'd hate to go any further than that.
Well, let me be clear, and I agree with that. I certainly didn't mean to suggest that an employer would be justified in basing its employment decision solely on some genetic information. But if you have an employee who is having serious medical issues as a result of performing in a hazardous job, and you request testing be done to ensure that that person can continue to safely perform the job, and that person refuses, I think an employer would be well within its right to, on that basis, it's almost a direct threat type of analysis, if you will, on the basis of its concern about the employee being able to perform the job in a manner that is safe for him or her, as well as safe to other people, without concern of a potential GINA violation.
I'd like to add just to be clear on what the plain language of GINA says. GINA does not allow an employer to require an employee to have a genetic test when they're in a potentially toxic environment. That is, plain language is not allowed under GINA. The question really remains is, what can an employer do for an employee who refuses to take a genetic test? And bear in mind that at that stage, the employer nor the employee in many cases would have any specific knowledge as to whether that employee was at any heightened risk for acquiring any type of genetically based disease. At this stage, the employee simply is refusing to participate in a test that might reveal the predisposition to a disease that might be affected by the environment. So the question, and when Congress put that voluntary language in, it was quite intentional. And in fact, I don't believe that originally that language was there in earlier draft versions. And that language was included because Congress believed quite strongly that the employee should have the control over their destiny, not the employer. So to the degree, it is my belief that with that intent, for an employer to put that employee in another position, that employer should be required to make that person whole. That there should be no penalty in essence, for refusing to engage in a genetic test that is their protected right to do under GINA.
I guess the natural flip side of that, Mr. Gruber, then, is that if an employee refuses to take the test, that employee has effectively waived any liability action he may have in the future against the employer for leaving him there. Would you agree to that?
I'd have to think about that more. That's a big if.
It's a complicated question.
That was certainly not contemplated under the discussions that I'm aware of, that this right to refuse was predicated on necessarily giving up any rights for protection against an employer who might be engaging in practices that could affect their health. In fact, I want to make clear that this area does certainly by no means protects an employer from any type of act that was in violation of the health and safety of their employees generally.
Oh, certainly, absolutely not.
And
But you know,
so
there are situations, Mr. Gruber, where there are conditions that exist in a workplace that even if an employer is following OSHA standards, they may, for certain persons, cause a heightened risk. And I think that implicit in the right not to give that, not to submit to that medical exam is the result that in declining that, you are also declining an opportunity to find out if you are yourself at risk. And so that would naturally be, would have an effect if you sought to sue your employer later on for not moving you.
Well, I'd like to add that over the course of many years of discussing the toxic exposure exception, with many experts across the country trying to come up with examples of how this would actually be in effect in the workplace. Only one single situation related to chronic beryllium disease, which there's only a handful of companies in the country that mine beryllium, and there's a genetic predisposition to chronic beryllium disease that heightened exposure to beryllium mining might turn into this disease. That's the only example over many years of discussions where a genetic predisposition could manifest itself as a result of toxic exposure. So the actual cases of where that might occur, at least at this stage, are extremely limited. So I don't expect this to actually occur very often.
Jeremy, let me follow up on that. This is Andy with APD. This to me is a good example where the science is going to move forward, right? And we may have trouble finding examples today, but 10 years from now, there may be a lot of things that employers are interested in doing and trying to identify people that would be at a certain risk for whatever. And to me, there's a lot of dangers here. One is we don't want employers to have incentives to go on a fishing expedition to figure out who the ideal candidates are for certain work environments and remove disincentives for them to make those work environments as safe as possible for everyone. Also, and Susanna could certainly comment on this, I know that Francis Collins and Kathy Hudson and others talk a lot about this, there's a tendency in our society to engage in genetic determinism where we assume that the genes are the key factor in determining whether something's going to happen. And that's not the way the science works. You know, there's a lot of factors that could go into play, whether a particular work environment is going to result in somebody developing a particular condition. So I guess I would encourage you, going back to the Vice Chair's question, to think about examples that can help deliver the basic messages to employers that you want to deliver. Don't go on a fishing expedition, and don't read a lot into genetic information that, you know, the science probably doesn't support. And Susanna, I don't know if you want to say more about that, but I know that's a danger that's out there.
It is, and indeed, even in the case of beryllium disease, there's differences of opinion as to the link between the genetic mutation and the development of the disease. Environmental factors are often critical in the way disease develops, often much more so than the genetic mutation. And in listening to the discussion among people who are more experts in the employment law part of this issue than I am, what strikes me is that in considering whether to take away the possibility of employer liability later on, if the employer offers a test up front, you are increasing the incentive for the employer to look for as many tests as possible that may or may not be based on solid science. Certainly today, there's not a lot of genetic tests that are available. We saw one not so good genetic test offered in the Burlington Northern case. I think that we have to be mindful of the balancing act, as you said, in thinking about where genetic testing makes sense and where it's actually could be used in itself as a tool for discrimination.
Just to go back to your example for a moment, Commissioner Barker, if you have an employer who, for legitimate business reasons, asks an employee to submit to a medical examination, not a genetic test, and that employee refuses, the employer should not be barred under GINA, and I don't believe that the text of the law would support an employer, barring an employer from removing that person from the position for legitimate business reasons. I just want to be clear on that. And furthermore, I appreciate the point about BNSF, and the legislative history discusses that case at length, but that case was 10 years ago, and we simply do not see that sort of thing happening in the workplace.
And that follows on my qualified, the medical exam is given to make sure that individual is qualified for the position, which has a job description, specific job description elements for qualification. So I think our comments are together on that.
Though I'd like to add, as I said in my comments, in contrast to the Americans with Disability Act, there's no job-related exception under GINA. And so the Commission must be mindful in issuing regulations that there is no exception for job-related, and that employers will have to be particularly mindful in their requests for information that does not occur.
These are very difficult issues that will have to be worked through. Thank you very much.
Thank you very much. Madam Vice Chair, any other questions?
No, I'm actually fine. Thank you.
Great. Well, let me thank again the panel. This has been very helpful. I think we started to uncover various issues that will be the subject of comment through the comment period, and the goal of this hearing was to start the discussion, and we look forward to a vigorous round of comments from the public. I want to thank Sharon Alexander of my staff, who took the lead in our office in pulling this together, again on short notice, and did a fabulous job. And wanted to thank her. I want to thank our colleagues in the Office of Legal Counsel for their help, and the panelists for coming to share their expertise with us today. The comment period will be open for 60 days. Once it's published in the Federal Register, we look forward to receiving those comments and hopefully soon thereafter issuing a final rule that will